right, Chapter 6, we're going to do understanding local, state, and federal laws that pertain to districts. So this is just going to be high level because there are a number of, pieces, at any of these levels that certainly the districts and the boards are going to engage with. But this is intended just to give kind of a high view of a couple, and then we can provide some resources for additional information as well. So next slide, Jen. So first and foremost, from really the technical assistance perspective, again, we've said that the districts are the lead source of conservation technical assistance in your area. So it is on a daily basis that you're engaging with landowners, operators, agricultural operations on any number of conservation questions. Often those activities are going to have additional needs outside the district. So those can be state and federal permits for an agricultural operator to be able to undertake conservation. And so while the district may not be the authority, issuing that permit per se, you're often that kind of source of information. So you're kind of that one stop where a landowner is coming and saying, what all do I need to know? And so the district has also helped often that kind of liaisoning and providing direction. So the state committee has put together what we think is a valuable resource here called a Farmer's Guide to Environmental Permits. It has a number of whether they be State Department of Environment, they can be Army Corps of Engineers for waterways permits. A lot of these are outlined in this permit guide. There is a link at the bottom of the page. This too is not completely comprehensive once you get into it, but it is kind of a fuller list. And so we recommend that the districts have this as a resource. There are printed copies as well as the website here that the districts and the Board of Supervisors can rely on or provide additional guidance as they're receiving questions from any number of agricultural operations. Next slide. So then another one on the administrative side, a really couple of key pieces here that we'll talk through, the kind of maintaining what we call freedom of information and compliance with those. So Maryland does have what's called an open meeting law. Again, the idea of being able to provide kind of transparency in government so that the individual stakeholder landowner can kind of understand the roles of the districts and the work that we're carrying out. So this state law really kind of speaks to how are public meetings conducted? What do they look like? What does that transparency and kind of guidance need to be? So it does require advance public notice of your meeting location, your time, and your date. And requiring such delivery of information to news media, posting notices, etc. So if they're going to be a monthly board meeting, those are often advertised on the website for the district. It can be a Facebook page. Some still rely on maybe your local newspaper. We encourage you to put those out at least a couple weeks in advance so folks have full notice of how to attend or access the meeting if it was going to be virtual. It does require that minutes of the meetings to be recorded and available to the public. So by recorded, we mean, typed meeting minutes. Those do not necessarily have to be available on the website, to download, but do need to be available such that if a member of the public were to say, I'd like to see your meeting minutes from August of 2022, those could be produced and you could be able to provide that to an interested stakeholder. The open meeting law governs the process and restrictions for closing of meetings from the public. So there are times when the district needs to go into what we would call closed session. That can be that you're getting legal advice from counsel. That could be that you're talking about a personnel matter that doesn't need to be discussed in public. So the state open meeting law outlines what are the terms and exceptions of when a governing body like the districts can go into a closed and private session. And there is a checklist and criteria of being able to do that. And all of those are available on the Maryland Open Meeting Law website. It is really key to stay in compliance with this, that a trained member of the district has gone through training with the Maryland Open Meetings Law. So this is not just the district manager, but the board members themselves. This is an online training offered. It doesn't take very long, but it does go through kind of the procedures and outlines the information that you need to know for both the public sessions and the closed sessions, and it would give you a certificate once you've completed the training. So this is a one that we say that at least one board member needs to have gone through the training to make sure, again, that there is compliance and making sure that folks are readily aware of what those open meeting law requirements are, and to reach out to state committee where we have questions or additional needs for guidance on issues as they arise. And so in tie with that, if you'll go back one slide, Jen, the opens meeting law ties with the Public Information Act. So they're two distinct laws, but the Public Information Act is in the case where the public, in addition to attending meetings or having access to maybe some of the meeting minutes, there are business and plans and documents and work products that the district is involved with. The Public Information Act is the law that would explain how those public records from government bodies can be accessed and distributed. So if there are certain conservation plans or documents that might have some sensitive information, the Maryland Public Information Act would talk about how someone would make those requests, how those requests would be reviewed, and then ultimately what would be disclosed from those documents request. Okay, next slide. So then we pair the State Public Information Act with its federal counterpart. So in federal, for the USDA, we call that Section 1619. That's Section 1619 of the Farm Bill. That is the section that discloses or prohibits USDA and its contractors and cooperators, that would be the districts, from disclosing information provided by an agricultural producer or owner of agricultural land concerning the operation, farming, or conservation practices, or the land itself. So this Section 1619 provision is very broad. It provides a lot of protection to an individual farm as to what records and information about their farm information can be disclosed. And certainly the districts as a conservation partner are also subject to these provisions. Each district signs an agreement between themselves and USDA's NRCS, and those provisions are outlined in that agreement. So again, we are subject to those provisions. They marry up very nicely with the state's compliance, but it's important to understand that there's a lot of levels of protection offered to these documents, and the district has the authority to be a custodian of those records in a way that's protective of the personal nature of some of the information. So when requests to review them or see those documents are made, particularly by outside parties, there are a set of rules and provisions that govern how those would be reviewed and disclosed. So to add to that, State Committee has been working with USDA on a guidance memo to provide some additional insight into kind of how these provisions should be being used within the district. And we expect a guidance memo, again, with just a little additional detail, to be issued in early 2023 and will be provided to all of the districts and the Board of Supervisors. Next slide. So then a couple of other laws of importance. These are kind of key employment laws. So really, there are broad categories associated both at the federal and state. Again, they have their own sections of law as to where they're kind of housed, if you will, but really speak to very kind of similar non-discrimination terms. So, if we go back to kind of the Civil Rights Act, a lot of those named prohibitions for discrimination on race, color, national origin, religion, sex, gender identity, sexual orientation, disability, age, marital status, all of those are protected classes of which someone's employment status cannot be discriminated based on any of those kind of protected classes in federal law, as well as in Maryland state law. So in Title 20 of the state government article, again, employees are protected against unlawful discrimination for any number of categories: race, color, sex, age, national origin, religion, disability, marital status, sexual orientation, gender identity, genetic information, and harassment and retaliation. The latter category of harassment and retaliation has been added more recently with specific interests and new new focus on sexual harassment and making sure that both the districts and the Board of Supervisors understand current state laws related to sexual harassment prevention. And that includes new training requirements that the state updated as recently as 2018 and has continued to update state law to make sure that folks fully understand expectations around sexual harassment prevention, what that looks like in the workplace, and the reporting procedures and compliance procedures. So MDA hosted a series of trainings on sexual harassment prevention in 2021 and 2022. We did in-person trainings across a number of areas and invited all of the board supervisors to participate, and we'll make you aware of any future trainings on this subject if they are scheduled. Next slide. Okay, another kind of protection, the liability and tort claim. We have spoken before about the districts being an independent division of the state. As a political entity, it does put you at a sue and be sued is kind of one of the powers of the district itself. But it's important to understand that the law does offer protections to both the district and individual supervisors through the Liability and Tort Protection Act in the state of Maryland. So what that offers is it protects both the district supervisors and its employees of any tortuous acts, so long as your duties were carried out within the scope of your duties as a board supervisor, that you acted without malice or negligence when you were carrying out the action, and that it stems from claims made within state law. So what that is saying is that those protections are housed and those protections offered and described in Maryland state law. If those claims come, or if there's concerns about a district or a supervisor that might create a liability or a legal dispute, the Attorney General, which has counsel sitting at MDA, would be contacted, and they would be able to provide additional guidance and support to the district. They do have the discretion to decide what that legal representation looks like, and how that support, like the capacity and the terms of that representation, and often provide that legal representation to the degree that the state, and the districts themselves are part of a lawsuit. So that can be the district, the individual supervisor, to individual employees within the district. Again, all of that legal support coming through the Office of the Attorney General here in Maryland. The Attorney General can choose not to participate depending on the claim and the nature of the suit, but certainly they have interest in representing the district and making sure that the goals and the mission is being upheld, and so are often kind of a key legal asset and resource that the districts are able to prescribe to get additional information. There is additional guidance on this in the form of an advice letter that the Office of the Attorney General offered in August of 2019 that goes into extensive detail about the liability and tort coverage offered to supervisors and to districts. It is several pages in length, but is a public document and can be provided to any of the districts if they wish to see the legal opinion of the Attorney General on this matter. Next slide.